In the matter of Mateen Cleaves, 16T 538FY. May I have your appearances on the record, please?
Good morning, Your Honor. Lisa Lindsay on behalf of the people of the state of Michigan, Special Prosecutor for Genesee County.
Good morning, Your Honor. Frank Manley on behalf of Mateen Cleaves.
And I understand we've set a preliminary examination for June 28, 2016 at 10 a.m. It's further my understanding we're going to devote the whole day to that, correct?
That's correct, Your Honor.
It's my understanding, Judge.
In chambers, we had discussions of some difficulties. I want to memorialize those for the record. I understand there's a videotape that the people proposed to show in the courtroom, and that the three of us, Mr. Manley, Ms. Lindsay, and I, all believe that this video should not be rebroadcast, or should there be any pictures taken of it. So I believe there's a stipulation that the video becomes courtroom only, no media. Am I right?
That's correct, Your Honor.
That's my understanding, Your Honor.
You wanted to make an argument, Mr. Manley, about me saying that I discussed with you in chambers this morning that I didn't think that the victim's face should be shown on television or in the print media, and I said I had to do a very detailed order pursuant to the court rule. And I understand, Mr. Manley, that you want to place some objections on the record.
That is correct, Your Honor. I believe that the time has come for this young lady to step forward and be seen. You know, she's been able to make allegations with a cloak of anonymity. She's not a child. This is not a case where somebody's alleging that there's a child molestation. She has been able, through the Wayne County Prosecutor's Office, press releases, all the media coverage, to smear Mr. Cleaves. We believe in the right of confrontation, and we believe that an adult who makes these types of allegations should be able to have her face shown, should come forth so the people can see exactly who's making the allegation. The fact that a blue dot or these protections that are designed for children primarily are even being talked about in this case is not appropriate in our position, or my position. We think that she should come forward as an adult and state in open court what she said happened. These allegations, Your Honor, have put Mr. Cleaves in a position where there's an unlevel playing field. She's been allowed to be called a victim, all of these things. Let's see her. If you're going to make these allegations, come forward as an adult and make them. Show your face. If you're going to make these allegations, Mr. Cleaves has been internationally exposed with these allegations. She needs to come forward. She doesn't need any protection. And I'd ask that the court, when the court makes this decision, that the court understands these protections were designed primarily for children, not for a 20-something individual. So that's my position, Your Honor.
Well, counsel has cited no case law as it relates to these protections being primarily for children. So first and foremost, his argument is without merit. The Sixth Amendment deals with the right to confrontation, which is satisfied when the victim comes in and testifies in open court. She will, in fact, be in open court testifying. What we need to do, once again, is to protect her from harassment, from people on the street and things of that nature, until these charges are decided. When the charges are decided, when and if it's found over to circuit court, when she testifies at that point in time, the media will be allowed to show her face. But at this juncture, I think for the protection of everybody, it needs to have her face not shown. And furthermore, a person coming up to come to court to make an allegation of the sexual assault is not smearing the defendant. Every woman who feels that they are a victim of sexual assault should be able to come forward and make that allegation. We are in court to determine what happened. I believe it is appropriate at this stage in the proceedings to have her face covered, just as it is appropriate not to show the video, to have that rebroadcast, because that is also being done for the protection of Mr. Cleaves. And just for the record, is his presence being waived for this proceeding?
His presence is waived for this proceedings. He's in the building, I'll say that.
Okay. Can I answer that?
You got one.
I mean, you kill your parents and you cry that you're an orphan. This isn't my motion. I don't have to present case law. It's presumed that witnesses are shown, their faces are shown. It's presumed she needs to bring some case law that says something about that her face needs protected. I haven't heard or seen anything. So the idea that my argument is moot, she's come forward with nothing except this willy-nilly statement of all women, which have nothing to do with this particular case. This case isn't about all women. This case is about one particular woman. So the idea that you can stand there and say that my objection is moot because I haven't cited any case law, there's not been one iota, one scintilla of case law that's cited to say that her face should be covered.
Well, there is a court rule that we are operating under. So there is a precedent for what we're doing.
Has that been cited?
We are relying on the court rule which the court has in its possession. Furthermore,
I wasn't done by the way.
One of the reasons why the protections are in place is so victims will not be intimidated from coming forward. One of the main reasons why criminal sexual conduct victims do not come forward is because of this kind of behavior. This kind of broadcast them, intimidate them, bully them, make them afraid to come forward. She will have her day in court as the defendant. And if the defendant is so anxious to have his day in court, how come he's out in the hallway?
Oh, now wait a minute, Miss Lindsay. We're not going there.
No, well, he's...
I waived his presence.
I mean, is this...
Let's not argue things
Are we preaching? I mean, is this...
I don't know.
I mean, we got a female preacher here today? Are we going to court of law?
You're talking over me. First of all, to set the record straight, this is not anybody's motion. This was the court's concern after having read the appropriate court rules. And this is court rule driven and judge driven. It's not driven by Miss Lindsay or by you. I just felt that it ought to be a subject that was open and discussed. As to your Sixth Amendment argument, I'm talking.
Okay.
As to your Sixth Amendment argument, I don't see any problem with this. This is the probable cause stage. This is not the guilt or innocence stage. You are going to have the opportunity, Mr. Manley, to cross-examine this witness. Your client will have the opportunity to sit in the courtroom and see her. She will have the opportunity to sit and see him and be questioned by Miss Lindsay. So I don't see any Sixth Amendment confrontation issue at all. It, in my opinion, just doesn't exist. The whole question before this court is, am I, pursuant to the court rule, going to stop the media from filming her face? That's my whole question. I know how you feel, Mr. Manley. I know how Miss Lindsay feels. And at this point, I'm going to take the matter under advisement. As I told you before, I will issue a written order as to what I'm going to do, and the news media will be provided with that. So right now, the order will read that the videotape is going to be introduced or proposed as evidence. I'm not going to say it's admitted yet. The videotape that is proposed is not to be filmed by the media or the print media, and I will take the issue of the alleged victim's face under advisement, and I will issue a written order.
Thank you, Judge.
All right?
Thank you, Honor.
Okay, we're done.
Oh, there's one
other thing.
One
Okay.
additional thing. I did indicate to the court, and I want counsel to be on notice, that at the conclusion of the preliminary exam, I would ask the opportunity to revisit bond. Our office has been in receipt of some information that there is another victim who may be willing to come forward. So for that reason, we think at that time bond should be revisited. And if there's any other victims in the interim who want to come forward, we will be bringing that to the court's attention at that time.
Yeah, I got to address that. You know, this has been a continuing pattern of Wayne County prosecutor to come into open court with all this media and talk about a potential, another allegation of some kind, again, to smear Mr. Cleaves. She wants to know why Mr. Cleaves isn't here. Ongoing smear campaign. She doesn't want to identify who the person is, identify who this person is.
Mr. Manley, I'm going to correct you. Mr. Cleaves is in the building.
Yes.
All right. So don't say he's not here.
No, but I mean, she made references somehow kind of trying to be cute that somehow he's not here because of some other reason. She tries to come forward with some specious allegation. Come on. Either put your lady on here, let's get it on.
Okay, I've heard this, and we will get it on. June 18th, June 28th, 2016 at 10 a.m., and we will dedicate the day and probably a couple of bottles of Aleve to this exam. Please understand, Mr. Manley and Ms. Lindsay, this is the probable cause stage, and that's all. This is not a guilt or innocence phase. I do not expect to try this case down here. All this is probable cause. Understood?
Thank you, Judge.
We're adjourned.